reading of Article 142 read with Article 191 and entries 58 and 55. That is my contention. First submission. Second, what I'm canvassing before your lordships is that the provision for right of appeal.
Before you come
No,
to
no,
right of appeal,
please go back. This is too wide. This is your contention is very general. Be precise. When you say 191, how do you relate 191? Which entry are you relating your 199 with? Are you relating it with entry number 55 or 58?
Both.
50?
Both. 50 entry 55 and entry 58. I'm relating it to both.
I think
My lord,
you said that in relation to the practice and procedure bits of
yes,
the Act, you are relating it to entry 58.
yes.
Okay, now the difficulty I'm having with that is I've told you what I think one aspect of it is, but coming now to the other aspect, you start with law under 191, you then relate it to a legislative entry which is 58. I'm just talking of practice and procedure part because and then you read it back, the principles of interpretation of legislative entries, you read them back into 191. Now, the difficulty that I'm having here is that if you look at 191 and think in terms of legislative competences, then the subject matter of that legislative competence is the practice and procedure of the Supreme Court. And on your reading of this back and forth, this has to be given the widest possible. The law enabling power has to be given the widest possible amplitude and interpretation and understanding. You will recall that the 1956 Constitution and the 1962 Constitution, both of them had specific legislative entries with regard to the Supreme Court, right? Specifically with regard to the Supreme Court.
Well,
jurisdiction, powers, this, that, and the other. Right? Now, the Government of India Act 1935, which also served as the first constitution of Pakistan up to 56, in relation to the federal court, the 7th schedule did not have any such entry, other than the only entry was other than what is now entry 55. But there was no specific entry. The interim constitution structurally, as does the 1973 Constitution, they revert the position back to Government of India Act 1935 in terms of the legislative competences, because I'm now focusing on your entry 58 argument. If that argument is correct, it seems to me that that indirectly resurrects a legislative entry with regard to the, specifically with regard to the Supreme Court, which has been removed from the legislative lists, and it recreates indirectly something which the interim constitution and the 1973 constitution very firmly say, as I understand it, modeling themselves on, in this regard, on the 1935 Government of India Act, that indirectly brings in, resurrects the legislative entries that were there in 56 and 62, which to me creates this problem. Firstly, as my learned colleague some while ago said in a different context, but this is indirectly amending the Constitution. Secondly, it seems to me the very broad manner that you are talking about with relation to 58, I think that puts in doubt whether law as used in 191 is supposed to be an enabling power at all, because you are now creating a legislative competence, as you say, in the widest, broadest possible terms, which does not exist in the Constitution. What would you say to that?
My humble submission is that, and reading of Article 191 is that when it says that Supreme Court may make rules and they shall be subject to the Constitution and law, I read it that on that issue, on that subject, there is a law or can be a
मैं आपकी जो है ना, I'm sorry to interrupt you, but I'm trying to understand जिस तरह आप इसको 58 से लिंक कर रहे हैं ना, the practice and procedure parts of this act, आप जिस तरह इससे लिंक कर रहे हैं, तो then necessarily the subject, the legislative power or competence of law in 191 has to be in the broadest possible terms. But that is only possible, it seems to me, if the 73 Constitution had retained what was to be found in 56 and 62, namely specific. आप जरा पढ़ें तो सही दीजिए आपको 60 56 Constitution दें आपको और 62 Constitution दें, उसमें वो legislative entries जो सुप्रीम कोर्ट की हैं वो पढ़ें तो सही ना, आप तो उस चीज को रिक्रिएट कर रहे हैं इनडायरेक्टली. आप काइंडली रीड दोस लेजिस्लेटिव एंट्रीज.
मरुड,
आप पढ़िए वकील साहब,
जी.
पहले पढ़िए तो सही ना. 56 का है हाँ 16 है ना, एंट्री 16 देखिए, फेडरल लिस्ट एंट्री 16.
The Constitution, organization, jurisdiction, and powers of the Supreme Court, including contempt of such court, and the fee taken therein, persons entitled to practice before the Supreme
और
Court.
अब आप इसकी देखिए 62 कॉन्स्टिट्यूशन की, वो भी चले ना रहने दें,
जी,
वो
जी.
more or less along the same line,
Yes.
just to save time. तो ये जरा काइंडली बताइए ना कि इसके अंदर जो आप जिस तरह रीड, उसका implication जो है, उसकी जो logical consequence है, does that not revive a legislative entry that perhaps consciously the interim constitution and the 73 constitution?
Sometimes, logical consequences flow differently for different people.
I'm waiting for your answer.
My answer is that it does not, in my view. My answer is that I am reading Article 142A as being the powers, that's where the powers stem from, the power to legislate in relation to matters provided in the federal legislative list. The federal legislative list, entry 58, and if we can maybe read it perhaps.
Mr. Zahid, Ibrahim, could I just to rephrase what you were saying, and if you want to look at it this way, maybe, perhaps, that you start off with 142A, jump on to 58, and now you bounce back to 191.
Yes.
But this time when you come back to 191, you look at it as an entry because 58 is telling you to look at it. And all you do this time when you read 191, you look at the legislative competence only. And you just say there is law mentioned which could do this, and that solves the mystery.
That is what I've been trying, that is my submission.
Are you
142
going in for the part relating to within the legislative competence of Majlis-e Shura,
Yes.
or relate to the federation? Which part?
The first part.
But the first part in itself doesn't give specific direction of competence किस चीज पर है. And as was said earlier,
Competition,
it says it
competence
would
in-
be anything and everything. So how do you say that from entry 58 matters which under the constitution are within the legislative competence? So then the question is, Where under the constitution are you getting the competence? from?
191.
191.
Then you're
191
reading
doesn't
subject to
provide
the
competence.
constitution.
So what is happening is, as I see it, is that you, as I said, from 142, you jump on to 58. 58 simply says, go back into the constitution and see if there is any legislative power.
Yes.
I come back to 191, but different, looking at 191 differently now. I just have to look at the competence. And I see that it says that there could be a law which could regulate practice and procedure. So that's, we just have to look at the subject matter. This time round, coming back after 58, we just look at the subject matter.
That is my reading. My lord, with regard to,
Mr. Zahid, you can always say, you don't have to agree with me. We are here to hear your contentions.
and I have respectfully
You can,
said it
I mean,
very-
you've been polite, you can say,
No, no,
don't need to agree with me.
I think it's fairly
But
clear.
Mr. Zahid, we have to
I've
understand,
only
we have
expressed-
to understand what you are saying.
Yes, yes, of course. And I've only
We
expressed
may
my
agree with you,
submission,
we may
of
not
course.
agree with you,
Of course, of course.
but
And
surely a judge sitting on a bench of the court is entitled, when a submission
I
of high
appreciate those.
constitutional importance is made,
I appreciate those
to
observations.
appreciate that.
I appreciate
And I
those
think you
observations.
appeared me enough times to know that this is the way I,
I appreciate those observations.
that's the way I look
चलिए,
at
आगे
things.
बढ़ें, आगे next point,
And
please
that's
चलें.
the way how.
I'm grateful.
that's the
Zahid साहब,
way
आगे
I'm
बढ़िए,
grateful,
please.
sir. The second point that I wish wanting to submit is that the right of appeal is nothing but extending the jurisdiction of the Supreme Court, which is provided under entry 55. And why do I say that? First, in relation to extending the power of the Supreme Court, the argument is that this can only be done where there is express authorization. And the counter argument is, where is the express authorization? There is none. And therefore, this is a redundant provision. You can't read redundancy into a constitutional provision. So, express authorization, I find it in a reading of Article 10A and 2A. And there is a judgment on this that I wish to cite, my lord.
No,
Just
Just a minute. Express authorization under Article
10F,
10A
right to fair trial,
and Article 2A.
objective resolution.
No, and Article 2A.
Ji.
So is it your case, now these are, as the very appellations A indicate, that these were not there in the constitution as originally enacted. Entry 55 has never been touched. It remains as it is. So is it your case that prior to these articles being added to the constitution, the answer would go the other way?
My,
Let's look at the constitution on the commencing day.
sir,
If suppose on that day or the next day, Parliament had made this law with regard to the right of appeal, there was no 10A then, there was no 2A then, what
Sir-
would you say, what would the answer be?
my answer is, and the question I think is connected to the larger question that 185 में अपील जहाँ पे कॉन्स्टिट्यूशन ने प्रोवाइड करनी थी कॉन्स्टिट्यूएंट असेंबली ने वो कर दी अगर उन्होंने नहीं दी है 184(3) में too bad, go back, make a constitutional amendment. That is the argument, right? My contention on that is that the parliament said yes, हम 184 में अभी नहीं दे रहे, but हम ये power दे रहे हैं legislature को कि entry 55 में हम डाल रहे हैं कि you can extend your jurisdiction if at a later
The
stage
word used is not extension. The word
Extend.
used is enlargement.
enlarge the jurisdiction.
Now,
yes.
how do you interpret the word enlargement? As I see it, enlargement is of something which already exists. There is no appeal which exists. So how can it be enlarged?
Mr. Zahid, there could be two interpretations to that. I mean, my loud thinking that enlargement in this entry would have two sets. One is the existing jurisdiction being enlarged. The other is creating a totally new jurisdiction. Still, the Supreme Court's jurisdiction gets enlarged. So it doesn't really matter. The express provision is required for the existing provisions,
And-
but for a new jurisdiction, you don't need any.
And
because it's
when you have two fair interpretations possible, which one do you go to? You go to the one
You see,
where the law will survive.
दो चीजें हैं ना, creating and in creating you are enlarging. Where is the part to create a new jurisdiction?
So that is where enlargement would come in. Most respectfully, sir.
Yeah,
Discuss-
agar if we give enlargement a restrictive meaning, then can you give me an example? When is it ever applicable then?
Sir, if I may
I mean, I
just,
can't think of a scenario. Maybe you can help me think of a scenario. If we give it a restrictive meaning, the enlargement is different from creation of jurisdiction.
But
Then
also,
where will it come into play when, let's say, this act did not exist, and I asked you, please enlarge the Supreme Court's jurisdiction, what would you do?
it's a matter of semantics, you see. I mean, it's just a word in the sense that suppose if there is a appeal provided, would you not say that the jurisdiction of the Supreme Court stands enlarged? So it's just a word, I mean, to be, and you've read the principles, widest possible interpretation. So
This is
we cannot be
enlargement-
lost in the word.
Enlargement of jurisdiction can be read with Article 175(2) or not, because it is a case of jurisdiction. No court has any jurisdiction unless conferred by the Constitution, by or under the law. So if you read the enlargement, is it not the appellate forum is not an enlargement of jurisdiction to the original jurisdiction of Article 184(3)?
indeed it is.
So it would be read with Article 175(2) or not, where the
Yes.
powers has been given.
Yes, certainly.
But the law,
My lord, what-
but the law over there would have to be a law that Parliament is capable of making. Which brings us back to the same
Sir,
question.
what will go back to
I-
same.
but you see, enlargement का तो example 185 में ही दिया हुआ है, और वो जो आपके वो थे ट्राइबल एरियाज की enlargement, वो एक्ट का नाम ही था enlargement of jurisdiction. लेकिन आपसे तो मैं सवाल कर रहा हूँ, उसका मुझे बताइए ना, आपने अभी 10A और 2A का जिक्र किया।
ठीक।
तो I'm giving
और
you
एक
an
चीज
example.
और है
आपने
इसमें,
कहा
जाहिर
कि
साहब,
मिस्टर
एक
जाहिद के अंदर
आप सुन ले, फिर
एक
मैं आपको
उसके-
एक और चीज उसी के
आप
जवाब
उसके
में बता
अंदर जो
दीजिए।
है एक बात आप कर रहे हैं कि जी पार्लियामेंट के पास शुरू से ही पावर था, उन्होंने कहा जब हमारी मर्जी होगी हम लॉ बना देंगे। इज दिस योर आर्गुमेंट?
पार्लियामेंट ने उस वक्त
नहीं बनाया लॉ, ठीक है,
नहीं बनाया,
1970
बट ये
but you say that inherent in entry 55 is the power to create an appellate right of appeal in respect to 184(3). Is this your argument?
absolutely yes.
Okay.
My lord,
Now, now appeal, is it a procedural matter or is it a substantive right?
it's definitely a substantive, right?
It is a
It is-
substantive.
yes, yes.
Learned counsel.
So you
Learned
can create
counsel.
a substantive right by implication.
Not by implication. I'm
Learned
not
counsel.
creating it by implication. I am saying that the injunctions of Islam mandate that you cannot deny right of appeal.
Learned counsel.
And the Honorable Supreme Court of Pakistan says that this is what the injunctions of Islam say.
Which case is that? Which case is that?
Trying to get to that PLD 1989 Supreme Court 6.
But the Honorable
Supreme Court, page 6.
Honorable Supreme Court also says that the lawmaker, if he intended
कौन सा है ये?
to,
ये भी
the
1989
constitution makers or framers of the constitution, if they had intended to provide an appeal, they would have done so. And if they by intention did not do so, and 185 comes after 184, then be it so. I mean, if they
Perhaps-
did not provide an appeal and now the Constituent Assembly wants to provide an appeal, let it do so, but let it be by way of a constitutional amendment,
My
and
lord,
not by
another way,
uh,
another way of looking at
by stretching entry 55 out of shape.
my lord,
Under
another way
counsel.
of looking at it, if we look at 184(3), वो तो इस्तेमाल ही नहीं हो रहा था, right? Later on, it started, and that is the reason that the parliament
कब
perhaps-
इस्तेमाल होना शुरू हो गया? किस आप बताइए ना, जो इस्तेमाल नहीं हो रहा
No,
था,
no.
make your point.
I'm trying,
तो चलिए आगे बढ़िए ना।
Learned counsel.
जरा आप चलते रहे ना, थोड़े आर्गुमेंट्स आपके हम नोट कर लें पहले।
In
जाहिद साहब प्लीज आर्गुमेंट्स तो बताएं।
That's how if I may, this is
Zaid Saab, as I've understood your argument,
welcome to the full court.
entry 55 is very crucial. It gives competence to the parliament in two ways. One is enlarging the jurisdiction. The jurisdiction which already exists, it's enlargement of that. And secondly is to confer supplemental powers. That is in the context of the existing jurisdiction. So any jurisdiction that exists
that can be enlarged. It is not a creation of a new jurisdiction. And it is the existing jurisdiction which is being enlarged. It is unlike Article 185, where the original jurisdiction is of the high courts of other forums. It's only the appellate jurisdiction that has been created and vested in this court. Secondly, coming back to the question, why was there a need? If the, as interpreted by this court till 1988, if 184.3 had been exercised the powers the way that originally were intended by the framers of the constitution makers, there would have been there wouldn't have been a problem. The problem started after 2010, when everyone was speaking about it. The voices came from the lawyers, from everywhere, that the power was being abused, and we need to acknowledge that. So now, in that historical context, merely the jurisdiction has been enlarged.
Indeed, sir. In fact,
Well, the first case that happened under 184.3 was in 1976.
but the
और
floodgates
उसके बाद-
opened later.
उसके बाद the 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So if I may just come to page 12.
But that it- 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So if I may just come to page
But
12
not that it
of
just
this judgment.
started, all of a sudden. I mean, it has been there all along in the constitution.
Indeed,
And for the first time, the powers were exercised in 1976 and,
floodgates opened later, sir.
yes.
Paragraph,
मिस्टर जाहिद
page-
प्लीज
ये आगे बढ़े ना थोड़ा।
जब हम पढ़ते हैं आर्टिकल 175 की क्लॉज 2 तो उससे पता चलता है कि दो किस्म की जुरिस्डिक्शन हैं
जी सर।
जो कन्फर हो रही हैं। वन इज बाय द कॉन्स्टिट्यूशन एंड सेकंड इज बाय द लॉ। तो दो किस्म की जुरिस्डिक्शन हो गई, कॉन्स्टिट्यूशनल जुरिस्डिक्शन और अकॉर्डिंगली लॉ की जुरिस्डिक्शन हो गई। अब इनलार्जमेंट अगर इन दोनों में से होनी है, अगर कॉन्स्टिट्यूशनल जुरिस्डिक्शन जो है जो 184 से लेकर 204 तक आती है जुरिस्डिक्शन, उसकी एनलार्जमेंट अगर होनी है, वुड इट बी थ्रू एन एक्ट ऑफ पार्लियामेंट और बाय अमेंडिंग द कॉन्स्टिट्यूशन? और दूसरी अगर स्टैट्यूट की जुरिस्डिक्शन की एक्सटेंशन होनी है तो वो क्या उस स्टैट्यूट की अमेंडमेंट के लिए एक्सटेंशन होगी, एनलार्जमेंट होगी, या वो भी एक्ट ऑफ कॉन्स्टिट्यूशन के अमेंडमेंट के लिए होगी?
सर अगर
ये दोनों को मिक्सअप हो रही हैं कुछ चीजें।
सर अगर सिर्फ कॉन्स्टिट्यूशनल अमेंडमेंट के तहत वो एनलार्जमेंट हो सकती है, तो
जुरिस्डिक्शन जो हैं वो 184, 185, 188, 186A, 188, 204 एंड 203 FE जो है शरीयत कोर्ट की, ये जुरिस्डिक्शन कॉन्स्टिट्यूशन में है। इनकी अगर एनलार्जमेंट होनी है, कैन इट बी डन बाय एनी ऑर्डिनरी लेजिस्लेशन?
sir, because otherwise you will have to read this provision in relation to enlargement as being redundant.
नो, वो एनलार्जमेंट जो है दो तरीकों से ना, दो जुरिस्डिक्शन आ गई। अगर दोनों की एनलार्जमेंट होनी है तो एक इंस्ट्रूमेंट है कॉन्स्टिट्यूशन, दूसरा इंस्ट्रूमेंट है एक्ट ऑफ पार्लियामेंट। तो एनलार्जमेंट करें उसी तरीके से करें, उसी तरीके से करें जिस तरीके से जुरिस्डिक्शन आ रही है।
If we say that the jurisdiction already exists, only to the extent of enlargement has the power been given to the parliament.
Enlargement, the concept of
We have got bogged down in
existence of some jurisdiction.
amendments to the constitution. If suppose parliament tomorrow enacts an amendment and says 184.3 is hereby repealed, ठीक है ना, अब तो कोई वो तो कर सकते हैं ना, हम फिर भी उसको देख सकते हैं
जी।
या नहीं देखेंगे?
नहीं, बिल्कुल नहीं।
नहीं, पता नहीं क्या करेंगे। So I'm just saying कि when we concede the power, या तो कहें कि पार्लियामेंट कर ही नहीं सकती है काम, 184.3 को डिलीट भी नहीं कर सकती, because we are saying this amendment could be brought only by way of a constitutional amendment. So parliament says, okay, thank you very much, now I repeal 184.3 altogether, full stop. So उस पे दूसरे arguments होंगे, is it the basic structure of the constitution 184.3 or not? But here again back to let's simple things, let's see them how they are written in the constitution.
If I may just read.
Can you just quickly
one
finish your argument,
yeah,
because we have a lot of counsel to
page,
hear.
I will, page 12 of this judgment, page 12 of this judgment.
Which judgment?
Uh,
ये जो साइड किया
PLD 1989, Supreme Court 6,
शरीयत appellate branch
Shariat Appellate Branch.
12E
12, sir, the second paragraph. As far as the question that the provisions barring the right of appeal in the defense service laws are not repugnant to the injunctions of Islam is considered, we cannot agree. This court has held that the Islamic injunctions of Adl, Qist and Ihsan warrant that an aggrieved party should be entitled to test the correctness of a decision which results in the deprivation of his livelihood. See Federation of Pakistan and Others versus Public at Large, PLD 1988, Supreme Court 202, wherein the validity of certain provisions of the West Pakistan Press and Publications Ordinance, including the provisions therein which did not permit an aggrieved party the right of appeal, was considered, and it was held that the said provisions were against the injunctions of Islam and must be amended, and the right of appeal provided. The need for testing the correctness of a decision which results in the deprivation of liberty and also livelihood would obviously be greater. The court's decision in Federation of Pakistan and Others, PLD 88, Supreme Court 202, has been reaffirmed in Federation of Pakistan General Public versus General Public, decided on 17/188. It was similarly observed. And indeed, the harshness in similar provisions of West Pakistan Press Publications Ordinance was removed by the court in the same judgment. Remedial measures were ordered. The Federal Shariat Court in its impugned judgment has also held that the right of appeal was recognized by the Holy Prophet, peace be upon him, as well as the Khulafai Rashidin, and discussed this question in great detail. Nothing has been shown to us in refutation thereof. The plea thus that barring the right of appeal does not offend the injunctions of Islam cannot be accepted. So, if we read Article 2A as if it is a substantial part of the Constitution, right of appeal accordingly has to be given effect to.
Mr. Zahid Ibrahim, the question here is not whether an appeal should lie or not. The question here is, if an appeal, right of appeal is not presently available and it is sought to be provided, who is competent to provide the appeal? And what mode needs to be adopted to do that? Now, one argument is that it can be provided by way of a legislative instrument, by an act of the parliament. The other argument, not provide a right of appeal, there is no right of appeal. And if you want to provide a right of appeal in the Constitution, in exercise of constitutional powers, those have to be provided by a constitutional amendment. And if you want to provide a right of appeal in a statute, then the statute has to be amended, because this right is a creature of the statute or the Constitution. And unless the instrument which provides the appeal, or unless the law that has to provide the appeal, it is amended, it cannot be provided by implication.
Mr. Zahid Ibrahim. Over here.
चले आप अपना पॉइंट तो बताएं ना, हम कुछ नोट ही नहीं कर रहे हैं. I'm not writing anything. I'm just hearing various queries. I mean, can you complete your submissions?
I hope.
Please complete your submissions, and then you can respond to all the queries.
In relation to.
Zahid Ibrahim,
Ji, my lord.
if I may. On your reading of entry 55, would it be possible for Parliament to make a law creating an intra-court right of appeal in respect of an appeal heard by the Supreme Court under Article 185? Would that be permissible?
Your Lordship has perhaps dealt with that question, where your Lordship has even said, well, the line that, and in the end, there must be an end.
No, that's review. But I'm saying, क्योंकि आप जिस तरह entry 55 को पढ़ रहे हैं ना, review का तो हमेशा ही है. And my question is, on your reading of entry 55, would it be permissible for Parliament by an act to provide for an intra-court right of appeal in respect of judgment delivered by the Supreme Court under while hearing an appeal under Article 185? Would it be possible on your reading of entry 55?
My lord, that would go against the finality principle, because
Well,
right of
always-
appeal against a right of appeal.
इधर आप
But the,
ये
lo-
अगर-
the
अगर
logic is
enlarge
that
करके
here there is no
अरे
appeal.
enlarge करके भी तो देखिए ना, अगर ये section 5 जो है valid है, which
जी.
is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me
मेरा
answer.
आप-
देखिए
आपका
जो
सवाल-
इंट्रा कोर्ट
सवाल
अपील
बहुत फर्क है।
इंट्रा कोर्ट अपील इज ओरिजिनल jurisdiction, never appellate jurisdiction. Intra court appeal, so if we can, there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court he is exercising, provided under intra court appeal. So that scenario may not be here at all, because 184, 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your lordship's question and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं, तो उसकी implications है ना?
जी.
अगर उसकी implications fail कर जाती हैं, तो that's one thing. उसकी implications alive रहती हैं, तो इसलिए समझने की बात है ना. या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी limit.
मैं ये नहीं कह रहा, मैं वाज़ेह तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement है, that exists not just in relation to 184(3), it exists. And my answer is, the line that in the end there must be an end, unless the parliament says so. Unless the parliament says so. That is my.
You added words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the parliament says so.
I may or may not agree with you.
Of course.
Subject to your.
Grateful, sir. Sir, if I may move to the next point, this challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105, at page 107.
Please repeat the citation.
My Lord, PLD 1994, Supreme Court 105,
At
107.
okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61,
2010 Supreme Court.
page 61. This is my Lord Chief Justice Iftikhar Mohammed Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants, which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10. I have drawn out what these international treaties say. I will just read one sentence from there, my Lord. Independence of judiciary, according to the Council of Europe recommendations, says, the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather which specifically says that from internally from the institution, there has to be independence. My lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners. How independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the parliament may make another law. But when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My lord, most humbly, under Article 184.3.
Zahid Ibrahim, how do you say that? Where the act obligates the Chief Justice or two other judges to act in a certain manner, and as was rightly pointed out by one of the counsels, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My lord,
I
you-
think this
you-
is,
your
this is,
lordship will give-
I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but if I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he's the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say. Use not the word independent, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
two very brief responses. Your lordship should give credit when this law was being debated in parliament. The very point that your lordship has said was also raised. And they said,
in
and-
fact, incidentally,
and-
there are two orders of this court, and the learned Attorney General also undertook to place on record
वो
the
तो,
debates,
in
which
an
have not
earlier,
been placed.
my lord, in an earlier hearing, it was
Fair enough.
pointed
So,
out that
I
it
mean,
is available
if
online.
that order
I
had
think it's been
complied
placed by
with,
one of the lawyers. It's available in CMA 8565. One
I
day's
think
debate
it's a
has been
good
placed.
150 pages.
Some parts of it have been
Acha,
placed
okay.
on the file.
Then all I was trying to point out that the questions that your lordship has raised, the parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it. I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April, and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
This itself is a vindication
Then
of this law.
can be fixed by the Supreme Court itself.
So,
If you point
so
out
all
it
the
out
government
the
is
Supreme
saying,
Court
all the-
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
How does the parliament come in?
Mr.
Order,
Zahid Ibrahim,
Then I
order
can
19
add-
of the Supreme Court rules, order 19 of the Supreme Court rules says that all appeals filed in the registry shall as far as possible be heard in the order in which they are set down.
Okay. So
Does it
it's a
happen?
question of
I mean-
implementation. So you, according to you, the rules are already there, they are not implemented.
No,
So if it is incorporated in a statute, it would ensure implementation.
it
Mr.
is not
Zahid Ibrahim,
incorporated in the
Mr. Zahid
statute.
Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door, which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red
Again-
herring.
And again, Mr. Zahid
The
Ibrahim,
main question is.
Mr. Zahid
the main
Ibrahim,
question
all
here
that,
is
all that
whether there
the
is a
parliament
door.
has done.
The door is the question that will determine.
The constitution for the
Zahid-
time being
Zahid Ibrahim.
does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether
I-
it all is a door or not.
Mr.
What comes
Zahid
through the door
Ibrahim,
is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has said. I view it differently. The parliament, since this court having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is try to structure the discretion, which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment,
No, I'm talking of the law. In light of this law, who is the master of the
I'm
roster?
not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc., etc.?
The committee decides.
Hmm?
The committee.
No, you're wrong. Committee is the creature and creation of parliament. At its broadest level, this law is a claim by parliament that parliament is the master of the roster. And I'm asking you a question.
I apologize.
You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says, let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe that those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say- I would-
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then there can be fast track cases, election matters, naturally election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give me this power so I can use it from the existing Supreme Court rules. Where do I have this power? I can't seem to find it. Can you help me with that?
And Mr. Zahid Ibrahim, there are no masters anymore in the world, you see. If you look around...
He always wants to undermine my authority.
With respect to
On
the
a lighter
master.
note.
So I don't see that as a master. So Mr. Zahid Ibrahim, what I want to say is that if you look at internationally, it's about time we wake up to the world, you see. We have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of fraud, master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
With due respect to the master
with
here.
utmost respect, I say we need to wake up to what's outside this room.
You see if I may add to that.
And to answer,
Under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
yes,
This is not a lifetime appointment.
but while they are there,
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here. I'm talking even way into the future. They will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is, in a sense, beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary, ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I could just
May
bring
I-
in another dimension to this, I don't know if you've looked at this new book called The Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge, but as a Chief Justice, he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
of course it does. And
And
let
again,
me,
Mr. Zaid
I've
Ibrahim,
also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters. If one man can do it, maybe 3 persons can do it.
your lordship,
Maybe 5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court. But that's practically not possible.
Mr. Zaid
The
Ibrahim,
point is, the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have
Please
the
answer
opportunity
that.
to answer
This
it.
point, Karan.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this is. Even in Parliament, when this was discussed, it was discussed that the bar has wanted to do this for a long time. PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any,
Not a
in-
question of whether they seek to be this.
or
or
they have
seek
not.
to-
Mr.
No,
Mr.
sir.
Zahid Ibrahim,
The principle that is being established is that they are. Whether they seek it or not is beside the point. This is
Mr.
the
Zahid
core
Ibrahim,
of the question.
I would
in-
humbly
in-
say that it is
Ibrahim,
not.
in
And
most
secondly,
of,
secondly,
Mr.
in
Zahid
relation,
Ibrahim,
Just on
Sir,
the
sir,
lighter
it's
in
an
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
no, is to not chase
Mr.
shadows. I
Mr.
would say
Zahid
not chase
Ibrahim.
shadows. And just one last thing. My lord, your lordship had said that, oh, chief justices are there for 1 year, 2 years, they go, new chief justice come and, there's no, it's not you're stuck for this forever. But my lord, what do we tell people who had
No,
homes
I,
in
I,
Nasla
I know, I
Tower?
think, no,
What do we
sorry,
tell
Mr.
people
Zahid,
who lost
Mr. Zahid-
jobs,
Mr. Zahid
employment,
Ibrahim-
That is not an
lives,
answer.
property?
Mr. Zahid
There
Ibrahim-
should be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, I mean, sorry to say, if anybody thinks in that side, Parliament, or in any other situation that he becomes all powerful, I at least will not let this institution put forward this thing, if we will do as we please. When we do. Here we have autocrats writing books, friends, not masters. We don't want to even say that. I am not anyone's master. I am servant to the Constitution and an abd of the Almighty. That is the place of a judge. It should remain there. It should not be variable commodity. Oh, the next is what? How will he do it? So I don't. This is a very unhealthy sign. If it is so variable, then where the Supreme Court's change laws. I mean, a law is enacted today. The way it goes up, interpreted by one court, by the other court, by the higher court, by the time it comes to the Supreme Court, takes about 20 years for any law to settle. Now, if it's such a variable commodity that we sort of stump everything and we come 184.3, today the law of Pakistan is this.
Certainly, we look for consistency,
Mr.
and that's
Zahid
what the
Ibrahim,
legal
I
system
think,
should provide. Yeah,
if I'm not wrong, in most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches. And they have named it as the natural judge concept. And they have done away with the concept of master of the roster. It's done on an objective basis, laid down criteria, and not on the basis of a discretion vested in one person.
I think it's high time that we bury masters and bring in trustees.
Yes.
In fact, the Constitution starts with that word. It's a sacred trust. Because you have mentioned Islam, but I was surprised nobody else is mentioning Islam. I mean, it's mentioned on the streets more than it is in the courts of law.
Most grateful, sir. Thank you for the opportunity.
Mr. Zahid,
Yes, sorry.
बड़ी इनके जो जितने भी मास्टर ऑफ रोस्टर्स प्रेजेंट और फ्यूचर के होंगे इनसे माजरत के साथ ये देखना है कि इस लॉ में आया ये बताया गया है कि कितने बेंचेस किस तरह बनेंगे या कौन बनाएगा किस तरह बनने में और कौन बनाएगा में जरा फर्क होगा
वो आप लोग आपके ऊपर छोड़ा हुआ है जिस तरह आपने कहा कि जो अगले आने वाले लोग हैं और जो हैं उन्होंने आप लोगों के ऊपर है ये पार्लियामेंट वहां पे नहीं फैसला होना है आप नहीं करना है ग्रेटफुल my lord. Most grateful. Thank you.
Who do you represent?
My Lord, I represent the PMLN. My concise statement is 8301 of 2023. My Lord, I'm sorry, I have committed the same mistake as some of the earlier councils. जो extracts or foreign judgments थे मैंने अभी दिए हैं.
8301.
I apologize, sir.
अब प्रेसिडेंट बन गया है.
Sir, I'll keep a mind of it. In future, sir, I'll be careful of it.
8301 अगर निकाल लें.
There should be a booklet in front of your lordships and the CMA. That is all I will be relying on. May I?
जी.
Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court.
चलिए ठीक है,
And
आगे बढ़ें.
sir, now on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the above can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution? Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a malafide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Meram Ali, Rawalpindi District Bar, Liaquat Hussain, Al-Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Justice Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading 2 short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the fourth stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6. In the first part of the final frontier, he deals with how judges have to rise above their own personal inclinations, ideological inclinations, biases, and so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary. Apart from the above, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches, allocation and distribution of cases amongst benches, attaching priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefits to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Now, of course, the author of this article eventually adorned the office of the Chief Justice of Pakistan, but nonetheless, for whatsoever reasons, no structural change could be brought about to achieve this final frontier of judicial independence. Now, this concern about the untrammeled powers, the untrammeled discretion of Chief Justices is not unique to Justice Khosa. Another future Chief Justice has also...
Mr. Salahuddin, it is a person-specific argument which you are raising before us.
Not at all, sir. What I'm saying is that this argument, this concern has been raised by multiple of your lordship.
The issue before us to come to that.
Yes, The issue that I am coming to, sir, is that there have been multiple concerns expressed by the judiciary itself about the concentration of powers in the office of the Chief Justice and the potential for abuse of those powers and the perception that it creates in the general public. Now, those are exactly the issues when Parliament is being accused
The
of acting with.
matter relates to the institution.
Yes, sir.
Please, we are sitting to hear you.
Let's go for let's look at the law. Your point is taken. You feel that there are voices coming from the bench. Fine, point taken.
Mr. Salahuddin, whatever you are saying assumes competence. That's the
I'm
one of
I
the
will-
key points over there.
I will come to
All
both
of this
those.
may be right, all of this may be wrong, some of it may be right, some of it may be wrong.
I
You
will-
Tell
I-
us about competence.
I will address the issue of
जी,
competence
तो
if your lordship will allow me.
ये तो चलिए, किसी का अपना व्यू है, होगा.
Sir, bilkul. I will cite, I'll just cite, not read from them, but I will cite the different judgments in which at least I think, if I'm counting correctly, 10 members of this present bench have raised concerns about the concentration of powers in the office of the Chief Justice. And my submission would be that that in itself dispels any argument of malafide.
Does that in itself confer legislative
No, sir, it
competence
does
on
not. It
Parliament?
does not, and I will deal with those
आप
independently.
उस तरफ हैं.
I'm just completing this, sir.
Kindly tell us what you say about who is Parliament the master of the roster?
Yes, yes,
As a matter of principle.
If you're, I will come to
उस
that,
तरफ
sir.
आइए ना, ये
I
तो
will
चले.
come to that,
किसी
sir.
की कोई व्यू है, किसी की क्या व्यू है.
Yes, I will come to that. I just want to quickly cite those judgments, sir. PLD 2019, Supreme Court, page 183.
183.
Yes, sir. PLD 2021.
What proposition is this?
Sir, these are all judgments and dissenting notes and additional notes in which different judges of this court have on various occasions
I think
raised.
you should be a bit careful. With all due respect, I don't
Ji.
want to stop you from making your submissions, but you're treading on relatively thin ice here, in the sense that if you're quoting a retired judge, that's one thing. But if you're quoting sitting judges in this particular context, before a full court, when the very competency of Parliament is under challenge, I think it's better for you to just focus on. I hope you understood what I'm saying. I don't want to say anything
I'm
further.
not, and that's why I'm just
It's not,
placing
please don't.
I would like to hear what you're
Views have
saying.
been expressed, they have been
I would like to
placing
hear what
those
you're saying.
judgments before your lordships. I'm not.
Citation
you
बताइए
cite
इसका,
Any extraneous
उसको
material,
जरा-
I'm not-
Yes, Salahuddin,
Please cite them.
citation बताइए,
Sir,
citation.
PLD 2019, Supreme Court 183. Then PLD 2021, Supreme Court 446. There is a dissenting note in that.
कोई relevant pages आप नहीं बता रहे हमें. Relevant pages.
Sir, I'll dig them out then, sir. PLD 2021, Supreme Court 446 में, sir, it is.
इसका टाइटल केस का क्या है?
Sir, ये PM's discretionary fund है. The earlier one is.
चलो लिख के दे देंगे pages.
जी, मैं दे देता हूँ,
आप
sir.
citations
जी,
दे.
मैं दे देता हूँ, sir. Then there is PLD 2023, Supreme Court, page 306. There is PLD 2022, Supreme Court, page 3006.
2023 Supreme
20,
Court.
PLD 2022, Supreme Court 306.
23 का भी आपने बताया, ये
जी,
22 का भी
23
same page.
जी, नहीं, PLD 2023, Supreme Court 306 and PLD 2022, Supreme Court 306.
दोनों both have the same
जी, sir.
page.
And उसमें this second one, sir, जो 2022 का है, that is suo motu case number 4 of 2021. And in
चलिए वो
that,
देख लेंगे ना. Let's just
I
cite
rely
them.
on paras 53 and 56.
53.
अभी citations ही दे दें.
That's it.
And sir, there is SMC number 1 of 2023. There are 3 report.
reported or not reported?
So not reported as yet.
SMC number?
1 of 2023.
ठीक.
And SMC number 4 of 2022. Now, in addition to that, sir, the bar councils and bar associations have obviously been passing resolutions on this issue for almost
All
a
due
decade.
respect again to the bars
Yes.
and councils.
Main
What
question
does that have to do with
My lord,
competence?
there is.
I mean, are we supposed to be swayed by, with all due respect to what, those are extra judicial
Not at all.
statements.
Not at all.
Kindly
Your
talk the
lordship,
language of the.
Your lordship will appreciate.
See,
Right.
कानून की बात कीजिए, ये तो नहीं
Mr.
कि-
Alvin, there are only two questions involved here.
जी sir.
One is who is competent, question of competency. And two, if we come to the conclusion that yes, there is competence, then you have to convince us that the law as framed is not in conflict with any provision of the Constitution. If you would kindly address these questions, I mean, most of your case would be
My lord, what
encompassed in that.
I'm grateful to your lordships. What the main challenge by the petitioners has been on two grounds. One, that it infringes, the legislation infringes the independence of judiciary. That is one completely separate issue. And the second is that it is beyond the legislative competence of Parliament. Now, in the legislative competence issue, obviously, whether the law is an excellent law or a terrible law is irrelevant. I will gratefully adopt your lordship's formulation on that. But as far as the challenge on the basis of independence of judiciary is concerned, the merits and substance of the law and its background is very relevant. That is why I'm briefly, I'll come to the legislative competence too. Sir, if your lordships will see that I'm not going to go through the resolutions or anything, but they're at page 171 to 185 of that booklet.
But
And if your lordship,
one thing, I've seen judgments of this court which have cited news reports for relying on various things, and consequences have flowed from those news reports. So I, for one, do respect what the highest bodies of lawyers have to say, whether it be the Pakistan Bar Council or the Supreme Court Bar Association, most ably represented by Mr. Abid Zubairi. So if you want to file those, I mean, I would place greater credence on them than on newspaper reports which have been taken note of and judgments passed by relying thereon. So if we keep talking about this chariot perpetually ad nauseum, the two wheels of the chariot, now let us see this chariot work.
it is, in my humble submission, is
But I think
that they are
competence,
relevant.
I think competence of a law has never been, as far as I
I
can
certainly
recall,
want to hear a person's point of view.
is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I'm dealing right now with the independence of
Right now
the
you-
seeming
No,
infringement.
but independence of the judiciary itself is, if it is violated, that then the law is incompetent. Competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
And what the people perceive independence to be, and more so than the people, those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that what I was able to discover were only dating back till 2018. But I understand PBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. And that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked two pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those two questions was, one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956, that power was moved to the 3rd schedule of the 56th Constitution and made subject to rules, and then by virtue of Article 177 made subject to Act of Parliament. This was after 1962, 1956. 3rd schedule में थी power that the Chief Justice may subject to rules, form benches, etc. And that was in turn subject to Article 177.
What about the power under the Government of India Act 1935, which was the first constitution of Pakistan from 1947 through to 1956? What was how was the power there framed?
In the 1935, I'll just read the exact.
What is the section?
Ji, sir.
Read section 214.
It is 2143. Subject to the provisions of any rules of court, the Chief Justice of India shall determine what judges are to constitute any division of the court
Kindly read subsection.
and what judges are to sit for any purpose.
Power of the roster.
Ji, sir?
The power of the roster.
Yes, it was there.
Now, actually, the power of the roster goes much further back in time. Have you seen the Indian High Courts Act of 1861?
No, sir. I have not.
Let me tell you where this power comes from and how it ends up in the judicial case law. You see, after the British took direct rule of India in 1858, one of the first laws that was made in 1861 was in relation to the power to issue letters patent to create high courts. Madras, Calcutta,
Yes.
Bombay, and all that. So this is something that goes back to the very beginning of British rule in India. Now, this provision, this Act of 1861, also had something to say in relation to that. Let me read out to you section 14 of this Act, 1861. Because at that time, there were only high courts, right? Federal court comes in 1935. The Chief Justice of each court shall from time to time determine what judge in each case shall sit alone and what judges of the court, whether with or without the Chief Justice, shall constitute the several division courts as aforesaid. So the Chief Justice as the master of the roster is a power that goes back to the very beginning of British rule and whatever follows thereafter. This position continues for several decades until we reach 1935. In between, we have the Government of India Act 1915. वो आपने देखा है? नहीं. उसमें भी section 108 था, which was in exactly these terms. ठीक है? अब आपका आ गया 1935 का Government of India Act, where you just read out for us subsection 3, right? Subject to rules made. But the rule-making power under subsection 1, legislature had no interference with that.
Yes, sir.
Then we have the
But the Governor General did. It was with the approval
subject
of
to
the
the
Governor.
approval. He didn't,
Yes.
he couldn't make them, he could only approve
Yes, but the approval in his discretion.
as originally contained.
My lord.
Now we come to the 56th Constitution, uske provisions aapne hame bataye hain. Then we come to the 1962 Constitution, where the article takes the shape that it now has. But the 62 Constitution, as I said when Mr. Ibrahim was arguing, in the third schedule, it had a specific legislative entry for Supreme Court.
Yes.
Interim Constitution reverts structurally to the position of
Government in India.
1973 Constitution does that. Now it seems to me that if you look at the grand sweep of constitutional history, starting from 1861 onwards, the 56th Constitution, which is perhaps the high water mark of legislative interference with matters relating to the power of the roster, out of those centuries-long period, this is a very narrow window, hardly a few years, right? This expanse, which I think is about 150, 160 years,
निगरान वज़ीर-ए-आज़म अनवारुल हक काकड़ की ज़ेर सदारत वज़ारत मज़हबी